Court's back in session. You may be seated.
Call the case of Cedar Mountain Estates, LLC and DAL USA versus Lawn 1 LLC. Council's ready. Approach podium.
Council.
You just wait 1 second.
Yeah, just 1 second.
Right.
Okay, go ahead.
Okay.
My name is Suzanne Hernandez. I'm here to represent the appellant Cedar Mountain Estates, as well as DAL or DAL USA. There's also another appellant named David Post. This is actually a consolidated appeal. Mr. Levine, who represents David Post, has sent me here as well to represent David Post. So I'll be arguing on behalf of both.
All right, let me ask a question as to Post. Did Post ever request a hearing on the motion to set aside the default?
I don't believe so, because it's actually one of the issues that we weren't afforded an opportunity, that David Post was not afforded an opportunity to be heard on the motion to vacate.
Well, I don't know what that means, an opportunity to be heard. If you submit a motion to the court and you don't ask for a hearing, then what exactly does that mean in terms of not afforded the opportunity to be heard? If you asked for a hearing and you were denied a hearing, then you haven't been given an opportunity to be heard.
I understand. I believe, Your Honor, that it's my understanding that he submitted the motion, it was denied, and a hearing had not even been requested.
Okay.
And
well, don't you think
what's the time frame between the time that does the record reflect the time frame between the time that the motion was submitted and it was denied?
It should, off the top of my head, I'm not sure of when that was. Only because I'm filling in for Post, so I don't have.
Well, perhaps if you're reserving some time for rebuttal, you could look that up while you're listening to the other side as well.
Yes, Your Honor, and I was actually going to reserve some time, just maybe 5 minutes.
Okay.
If you didn't ask for a hearing, there were no affidavits. The motion itself wasn't sworn, and there were no affidavits. And I'm not talking about meritorious defense, because that can be alleged within the four corners of the pleading. But you certainly can't really argue within the motion itself, in the sense of due diligence or excusable neglect. Those are things external to the many of the formal pleadings, not the motion itself. But that wasn't sworn, and there were no affidavits. If, in fact, he hadn't asked for a hearing, then how can you show reversible error by the trial judge in this case?
By not granting the motion to set aside the default as to Post, correct?
Right.
Well, based on the appeal, in Post's initial brief, it is indicated that sworn affidavits wouldn't have to be.
Well, you can do it either one of two ways. You can either, if you have a hearing, you can present evidence, or you can have sworn affidavits attached to the motion. Right. So I think that you can go either of those two ways. But if you're going to not file affidavits, and I'm going to, quite frankly, most folks either have the motion is sworn to, and they very often will have affidavits accompanying the sworn motion. But if you're not going to do that, then you better request a hearing and present evidence.
Right. I understand. According to a case called Net 1, which is actually a 5th DCA case that was cited in the brief, it's Net 1 LLC versus Christian Telecom Network LLC, 5th DCA case from 2005, it actually indicates in there that you can disclose defenses in a defensive pleading or an affidavit. So Post, instead of submitting an affidavit, decided to submit the defensive pleading, and what Post specifically did was in the Cedar Mountain...
Well, that deals with defenses. That doesn't deal with the excusable neglect that you have to show, correct? I don't think any of us, I think all of us are on the same page with you in that the pleading itself would be sufficient to establish the meritorious defense. I think the question relates to what sworn evidence is there in support of the allegations that there was excusable neglect.
And then due diligence.
And due diligence.
Yeah.
For the excusable neglect, in the order denying post's motion, the trial court cited to Brandt v. Dolman that inaction because of belief that the co-defendant's attorney would be representing defendant is excusable neglect. So the judge actually put in the order that that post would have satisfied the excusable neglect based on that, based on post's belief, based on what he was told, that the attorney for Cedar Mountain Estates and DAL or DAL USA, their attorney would be representing post's interest as well. So based on that belief, that's where the excusable neglect comes in, and the trial court recognized that and actually put it in the order. Regarding due diligence, although no, there was no affidavit that was submitted, Post reasonably relied upon another member of DAL USA, which is an individual named Troy Powell, who's a member of Cedar Mountain Estates. Post believed the representation by Mr. Powell that Post was being represented by an attorney, the same attorney that was representing Cedar Mountain Estates and DAL USA. So that's where the excusable neglect comes in and the due diligence. Specifically as to the due diligence, once Mr. Post learned, I'm not represented, a default had been entered, he retained Mr. Levine's firm, and then of course the motions were filed, which was approximately within a 10-day time frame of when the motion for summary judgment was entered into. So it wasn't specifically that a sworn affidavit was submitted in order to show the excusable neglect and due diligence. It was more his actions, with the exception of the meritorious defenses and the amended answer, the purported amended answer that was attached as an exhibit. Cedar Mountain and DAL USA's main issue was that there was an abuse of discretion by the trial court by not granting the motion for leave to amend. It is our position that it is in the interest of justice for the appellant to be granted leave to amend. Rule 1.190A says leave to amend should be granted when justice so requires.
Now, what was the time frame vis-a-vis the hearing on the motion for summary judgment? Wasn't it just immediately before the hearing on the motion for summary judgment that the motion for leave to amend was filed?
1 business day.
Why so late?
It's my understanding that Mr. Powell, who is a member of Cedar Mountain Estates and DAL USA, we hadn't been representing him. Our firm had not been representing him the whole time. We had filed an answer back in May of 2007 on the 2 corporations' behalf. It was just an answer with asserting no affirmative defenses or counterclaims.
Not the friendly foreclosure concept.
Right. That comes later in the proposed amended answer.
Why would you wait until the day before summary judgment? I mean, once they filed, if purportedly you have this friendly foreclosure action and there's negotiations going on behind the scenes, as soon as the motion for summary judgment is received by you, much less before it's set for hearing, wouldn't you reasonably take action at that point?
You mean and just assert it in the first answer?
As soon as they file a motion for summary judgment, that's not a real friendly action.
Well, apparently you're correct in that there were negotiations going on between an individual named Gary Clark, who was on behalf of Loan 1, as well as Mr. Powell and Mr. Gordon, who is the attorney at the trial level and who still is. There were negotiations going on all the way up until about the week before the motion for summary judgment. And
the hearing or the filing of the motion?
I believe it's the hearing, because the week before the hearing is when we were actually retained.
Is this of record at all?
I'm sorry?
Does the record reflect the facts that you're talking about?
Regarding when we were retained?
Negotiations that would have happened out between the parties.
It is in the October 29th motion hearing where Mr. Gordon was telling the trial court judge about this. So that's why it was filed the one business day beforehand, because Mr. Clark apparently was indicating that foreclosure actions were not going to be filed. You don't have to worry about anything, and they were just negotiating back and forth. Before you know it, this was set for a hearing. We ended up getting retained and filed one business day beforehand a motion for leave to amend the answer in order to assert affirmative defenses as well as a counterclaim. There is case law that indicates that talks about the timeliness or lateness, whichever word you'd like to use, as to when to file a motion for leave to amend. And there are numerous cases that show that there's one case where the motion for leave to amend was actually filed, actually heard the day of a jury trial, but prior to the jury being sworn, and it was denied, and of course that person appealed. Another one was filed a couple of weeks before the motion for summary judgment was supposed to be heard. And in these particular cases, the appellate court had said that the leave of amend should be granted when justice so requires. They cite to that rule, and it would be reversible error by not granting it. There was no prejudice by the other side, by the opposing side, in this case Lone One, in that these were issues that could have been investigated during the discovery or pleading phase of the case. So it's not like they wouldn't have had an opportunity to investigate the case and the allegations as well, so they weren't prejudiced in any way. And then, of course, had it been granted at that October 29th hearing, the motion for summary judgment that Lone One filed would have been, of course, moot at that point. Also, Florida Rule of Civil Procedure 1.190A provides, at any time in furtherance of justice, upon such terms as may be just, the court may permit any process, proceeding, pleading, or record to be amended or material supplemental matter to be set forth in amended or supplemental pleading. And that's exactly what we have here. It specifically says at any time. So the fact that it was filed one business day prior to the hearing on the motion for summary judgment should not matter, according to the case law and the rules. And I guess the real point is that there's no hard and fast black and white rule that says this is when it should be filed. It's actually very, very liberal, and the cases indicate that. The DCA's...
As a former trial judge, though, I can tell you that it's very frustrating to have lawyers file things the day before or the morning of a trial when you've got a calendar to run and you've got, 1,800 other cases that you're dealing with.
Well, absolutely, but respectfully, although it's frustrating to the trial judge, that's not what the rule says, that's not what the appellate courts say. The point would be that even if it's at the 11th hour, as the trial judge had indicated, even if it's at the 11th hour, 59th minute, and 59th second, it's not late and it should have been granted. The motion for leave should have been granted. And again, this was still within the pleading stage of the case. It was
the standard on review would be what?
Abuse of discretion in this particular case. So we're indicating that this is actually an abuse of discretion by the trial judge by not granting these motions. And the same thing for in post position. It's still abuse of discretion. Another issue is that the trial court made no specific finding of abuse or prejudice on the record. There was nothing to indicate that the other side would have been prejudiced in any way by even granting this motion for leave to amend. And our other issue, our meaning Cedar Mountain Estates and DAL USA, one of the other issues was that the proposed amended pleadings were futile. We're indicating that they were not futile. It appeared that the trial court was making a decision of indicating that the facts and the allegations in the amended answer were futile, and he also indicated, the judge also indicated, that it lacked a general indicia of reliability. So in essence, what the trial judge was doing was dismissing the counterclaim based on the facts, and these facts really should have been an issue to go to the jury later on down the road.
It looks to me like the post-motion to set aside the default was dated November 7th, 2007, and then the order denying December the 3rd, a little less than a month later. Does that sound right?
December 7th, it was filed.
November 7th, the motion, and December 3rd, the order denying. Anyway, you have about 4.5 minutes left if you want to save that time.
Okay.
Okay.
Regarding post...
Or you don't have to.
I'm sorry?
I said you have about 4.5 minutes left
Yes.
if you want to save that time for rebuttal.
Oh,
or you can use it now.
Yes, yes, please.
Okay.
Thank you.
Good morning, Your Honor.
Good morning.
My name is Rory Weiner. I represent Lone One. Your Honor, the appellant's position as to the motion for leave is not about when it was filed, even though I believe the trial court was not happy about the timing. In his order, he does refer to it as 11th hour filing. It was about what was filed. And the lower court clearly set out his reasons for denying this motion to amend. And that was, and he stated quite starkly, the pleading was futile. And he stated that during the hearing as well.
How do you know a pleading's futile at pleading stage? No discovery has been conducted. It's not summary judgment. It's not directed verdict. We're at a pleading stage. And so the issue for the trial judge is whether the pleading sets out a cause of action, period.
Or defense.
Or defense.
That's right, Your Honor. And what he cited to was the Thompson case out of the 4th District, and he also cited to the Maui case out of the 4th District. And his reasoning was that the pleading that was to be amended, that was proposed, was insufficiently pled as to the fraudulent counts, and he argued that the pleading was contradictory. And the two cases that he cited, in particular, the Thompson case was a mortgage foreclosure case where the person being foreclosed on, about 2 weeks or very soon before the hearing, did file for an amendment to allege fraud. And in that case, the district court affirmed the denial of the amendment because the trial court had said, look, this fraud count is not sufficiently pled, it's not specific enough, you've got to plead with specificity. And in particular, in the Thompson case, the trial court said, in fact, the statements that are alleged to be fraud are opinions.
But looking at the defense raised in this case, what's insufficient about the fraud allegation?
Well, for example, there's no allegation about when this delay, the timing, was Lone One and or Gary Clark, who is allegedly making these agreements, supposed to delay for a month, for 2 months, till this was completely developed, half developed. All it says is that Gary Clark represented that he would delay the ultimate foreclosure. There's nothing specific about what he lied about. Did he lie about how long he was going to delay? We don't know. The alleged friendly foreclosure, in fact, was...
But isn't that a potential defect that could have been remedied by further amendment?
Yes, it could have. However, in this case, the trial court did not abuse his discretion to look at these pleadings and look at what was pled earlier and conclude that this is insufficient. His rationale under the abuse of discretion analysis was justified, it was logical, it wasn't arbitrary, and it cited cases similar to the case in front of him. It cited the Thomas case and the Maui case. This was a reasoned decision that...
This isn't like Thomas in Thomas it was clearly opinions. You can't state a fraud cause of action based on opinions. This is if this is a promise that they're alleging to not foreclose, in that the other side relied on that promise to their debt. I mean, that doesn't seem similar at all to me.
Well, the other reason that the judge found, and there were 4 reasons that he found it to be futile. The other reason was he said it contradicted prior pleadings.
Well, I'm having a hard time finding a contradiction if you just are stating affirmative defenses that you didn't state before. I mean, there's no contradiction there. You're maybe adding to your silence. Well,
here's the contradiction. One of the contradictions is the first affirmative defense is the allegation that a secret oral argument or an oral agreement was made, this friendly foreclosure. Well, in the original answer, CEDAR admitted that it was the maker of the note and the mortgage and that it was liable under the terms. In that mortgage, which is part of the record, one of the terms is no oral modifications to this mortgage. Anything that's modifying this mortgage must be in writing, signed by the party. So there was an explicit contradiction.
Is that one of the ironies in the law is that you can waive that provision orally? I mean, there are plenty of cases that say that, correct?
But in this case,
But they never, I mean, to me it would be a contradiction if they pled that there was no oral agreement and now they're saying there was an oral agreement. I mean, they just...
Well, the contradiction is that on the one hand, they're admitting that they were bound by terms under which they were operating, the mortgage and the note, and then saying we're not bound by these terms. We can come up with oral agreements that are different from these terms. I think that's where the contradiction comes in. Also, the fact that this oral agreement is laid out in such scant detail. For example, when they file their motion for leave to amend, they file this on the 26th. The summary judgment notice was sent out August 24th. Between that time, there are no affidavits, and in fact, even at the time of the hearing, there are no affidavits from any of the individuals who would have been part of either hearing these statements or, in particular, Troy Powell, a principal of the company of CEDAR, or Mr. Post.
We understand the frustration that the trial judge would experience.
Sure.
But the law on allowing amendments is very liberal.
It is, Your Honor. And the difference here is appellant cites a number of cases where it talks about this liberality. But in all of those cases, and I believe versus the cases that the judge cited here, in all of the cases that the appellant cites, in those instances, the facts were so, you might say, unreasonable not to allow the amendment. For example, the Young case, which is a 5th District case. In that case, Mr. Young, who sued on a backup contract, failed to attach the appropriate exhibit. It was the wrong draft of a contract. That had originally confused the judge. He did not allow for the amendment to fix that. And the 5th DCA said,
well, isn't that a contradiction under your definition? They alleged in the first one that this was the contract, and now they're alleging that something completely different was the contract. Why isn't that a contradiction under your definition?
Well, because it wasn't two different terms. What it was is that the exhibit that was left out had terms in it that the draft exhibit, which was originally used, did not have in it. And so Mr. Young had simply attached the wrong exhibit. The appellate court said, well, to not allow him to amend, to simply attach the right draft of the contract that he's suing under, that would be an abuse of discretion. In another instance, in the case of Montero is a good case that they also cite. They also cite Lewis and Greenberg and Azemco, and all of these cases, in particular Montero. During discovery, evidence showed that there was a reason to believe that a contract was not accepted, which changed the statute of limitations from 1 year to the statutory 5 years. This was during discovery. The trial court had not allowed the plaintiff to amend to say, look, I did not fail the statute of limitations. I have 5 years. I don't have 1. The evidence in discovery shows this. And the DCA said, well, that is an abuse of discretion. I mean, that seems unreasonable, not to allow somebody who clearly discovered this, that they have not failed on their cause of action, to go forward. And in each of these cases...
So are you arguing for a new rule that it's a liberal amendment rule if there was a mistake or if there's something new discovered during discovery, but otherwise it's not, we don't have a liberal amendment rule as far as that?
No, not at all. I think that what the cases show, and what is happening in this case, what the cases that the appellant cites, is that the abuse of discretion standard, when applied in those cases, one backs up and says, what, as the Caracas case defines our reasonableness standard that we're supposed to use when it comes to abuse of discretion, what was in front of the trial judge, and what were the factors that could, and consequences to the particular plaintiff or defendant in that particular case. And in those cases, what lines up is very specific mistakes that were made, things that were discovered that clearly showed a viable cause of action. Some of the terms that these cases use is it apparent that there's a cause of action or not apparent that there's a cause of action? When you line up those cases with this case, and the Maui case and the Thompson case, and then there's also the Davis case, which is from the...
Why wouldn't it be a valid cause of action and a valid defense if your client said, there was an agreement, your client said, okay, I know you haven't paid, I know I can foreclose, but I won't foreclose if you'll go ahead and spend more money and develop this property and put in millions of dollars, and then foreclosed anyway? Why wouldn't that be a valid cause of action or valid defense?
Well, if it was developed sufficiently enough, it might. But the question here is, did the trial judge abuse his discretion under the facts that were pled and under the cases that he analyzed? And what I'm submitting is that when taken from that vantage point, this panel, as I think Your Honors well know, can, and that's the point of the abuse of discretion, can disagree with how the trial judge decided the case under an abuse of discretion. But it's a test of reasonableness. Was it reasonable for this trial judge, given the pleadings as they were pled and the cases that he cites and analogizes to, were those reasonable? And I would submit that his decision lines up nicely with the cases he cites and the case like Davis that came out of the 5th D.C., where it was a case of a woman alleging negligence for emotional distress. She was a teller given a note, give me your money, in a bank robbery, and she tried to bring a cause of action for pain and emotional infliction, and it was denied because of workman's comp exclusions. But then she argued, no, workman's comp doesn't cover pain and suffering, so I can bring a negligence case. And the trial judge said, well, no, actually, because under the law, under the impact theory, you wouldn't have a viable cause of action. Now, she could have developed that more, I suppose, and she could have been allowed to do some more discovery and find out whether or not there was sufficient impact. The only thing she alleged, and they said was an impact, was the robber handed her the note and she held on to it. But there could have been more discovery. But at that stage, the judge said, well, this is not a viable claim. And given the cases in front of him in the Davis case, he was affirmed as that was not an abuse of discretion. And that's what I'm suggesting here, is that the law allows the trial judge an abuse of discretion, and the trial judge in this case in front of him had the pleading, which was an alleged, for the defenses, was an alleged oral agreement, and this alleged oral agreement was between a principal of Loan 1, allegedly Gary Clark, and
I think we understand your argument on this point. Let me ask you to address Post and the motion to set aside the default. And can you tell me where in the Rules of Civil Procedure there's a requirement that the allegations of due diligence and excusable neglect have to be sworn to, or I mean, not sworn to, but have to be, the motion has to be sworn or include an attached affidavit.
Right. The rule references excusable neglect. This is 1540, excusable neglect and due diligence, but the cases are well settled.
Well, Rule 1.030 says that no pleading needs to be verified unless so stated in the rules, correct?
That's right.
And Rule 1.500 on defaults doesn't require a motion under that rule to be sworn, does it?
It doesn't, but the difference is that those are pleadings that you can choose to verify or add an affidavit. So the cases have been well settled that you need sworn evidence.
Right.
No, you don't have to do it by sworn pleading, because the rule says you don't.
Okay. So
but attach an affidavit, and this court has followed.
you don't have to attach an affidavit either.
No, you can do a sworn pleading.
Or you can put on testimony.
Or you can put on testimony.
How do you deal with the Smith case that says it's reversible error for a trial court to deny a 1.540 motion without affording an evidentiary hearing that would allow the movement to put on sworn testimony? If the allegations are sufficient that if proven, they would be a basis to set aside.
Sure, and that would be applicable if a oral testimony was asked for here. A month had gone by since Mr. Post filed his motion to vacate. He never asked for a hearing on this to allow the judge to say, no, I'm not going to give you a hearing. They mentioned, the appellant mentions that there has never been afforded an evidentiary hearing. Not even in his motion to vacate does he say, I would like an evidentiary hearing.
Is that normally something that would be of record? I mean, normally requests for hearings, in my experience as a trial judge, weren't placed in writing. Normally the movement would call a judicial assistant, and normally it would be a little bit of time. I mean,
and that would be the...
I mean, would it really even be normal that you'd be able to get a hearing over the holiday period, Thanksgiving, in a 3-week period? Or it was a little more than 3 weeks before the motion was, between the motion and the order.
Sure. But I think that would have been the burden of Post or Post counsel to put in the record, either by affidavit or sending out a notice, even if he couldn't get a hearing date, putting something in the record that I tried to get a hearing.
When have you seen that? You file a motion, you call Chambers, you try to schedule a hearing. When have you seen an attorney put in the record a notice that you're contacting Chambers to try to schedule a hearing?
Well, I mean, putting that in the record after the appeal, but after the appeal, but when the order's denied, the appellant in this case had nothing, and I see Your Honor's trouble here. I mean, how do we find out if there's been any?
Well, but there was no motion for rehearing that indicated we asked for a hearing and didn't get one.
There was no motion for rehearing. There was. I think that would have been the actual proper mechanism.
I mean, there's no indication that I can see in the Smith opinion that the party requested a hearing. The 5th DCA just said that panel, Judge Griffin, I think, said that it was reversible error to deny the motion without affording a hearing. That, to me, says if you get the motion, you can't act on it in 3 weeks and a month. You have to tell your JA, call the party, schedule a hearing on this before you can act. I mean, that seems to be the import of that case. Is there any indication in that opinion that a hearing was requested in the Smith case? I
don't believe there was, but I don't believe that case, and I can represent, of course, I don't know of any other case that mandates sua sponte. You've got to set up judge has to set up a hearing. I believe that language, which is consistent with these types of motions, means that it's the moving party's burden to try to get a hearing, and if a hearing isn't given, to move again for a rehearing, and get some evidence in. But I don't believe that Smith stands for the proposition that the trial judge, sua sponte, has to and is required to set a hearing for the parties.
Well, the holding is it's reversible error to grant the motion without affording a hearing. Isn't that the ruling in Smith?
It is.
And did the trial court here afford a hearing?
The trial court, I believe that the predicate for affording a hearing is requesting it. So I don't know, to answer Your Honor's question, whether or not there is
You don't know whether one was requested or not?
I don't know if one was requested in the Smith case. And I don't know whether or not the case law says that there is a requirement to get a hearing set by defining affording a hearing equals getting a hearing set necessarily. I just don't know the answer to that.
So in your view, if the movant filed the motion and the trial judge took a look at it, 3 days later, no one had called to request a hearing, the trial judge could deny the motion if it wasn't sworn or wasn't accompanied by an affidavit because a hearing wasn't requested within those 3 days.
That's right. And I believe it would be the province of the movant to request a rehearing or to request well, in particular, a rehearing on that motion to amend. I think that
there's no case that says that. There's no rule that says that, but you just think that that's the way it ought to work.
Well, I don't think that's the way it ought to work. I just say that there's nothing in the cases that suggests that a hearing is necessary, an evidentiary hearing or a hearing generally is necessary before the judge rules on it. I think that
doesn't the holding of Smith saying that it's reversible error to deny the motion without affording a hearing sort of suggests that a hearing is necessary? It
suggests that, but as I said, I don't know if that there is a rule that requires that. In practice, the attorney will, and that's the point of the sworn testimony, the attorney will attach or have evidence attached to the motion. And that's all that's required. And for instance, the appellant here refers to the...
I thought you conceded that that was not required under the rule. You don't have to attach your sworn evidence to the motion. You just have to allege facts that, if proven, are evidence.
I said that you don't have to have a sworn pleading. You can choose the option of attaching an affidavit.
Okay, and where is that requirement in the rules?
That requirement is set out in the cases, Your Honor.
Well, don't the cases all say either sworn either live testimony or an attachment or sworn motion?
Yes, some kind of sworn evidence has to be a part of that. And quickly, the appellant referenced the Brandt case that the trial court looked at and said, if there were sworn testimony here, there would be legal excuse, but there was no sworn testimony, nothing attached. Now, under the abuse of discretion standard, that was within the judge's purview to rule. It would be reversible if there was attached and he still denied it. Then we would be discussing whether or not what was attached on its face was sufficient. But here, the cases, and Net 1 does this from the Fifth Circuit, the cases are well settled that you got to have some sworn testimony as to your excusable neglect. And the judge, in his opinion, cited Brandt and said, well, this kind of reliance, that is the facts in this case...
You're about a minute over your time, so thank you very much.
Thank you, Your Honor.
I'll add another minute to your rebuttal time. Count for that. A little over 5 minutes.
Just to address some of the issues that were discussed by Lone One, the last thing that was discussed regarding needing a sworn motion, that post-motion should have been denied because there was no sworn motion attached. There is actually a rule which is cited in one of the briefs, which I didn't hear Your Honor indicate, although you may have, but it's Rule 2.515, Signature of Attorneys and Parties of the Florida Rules of Judicial Administration, which talks about an attorney's signature and says, except when otherwise specifically provided by an applicable rule or statute, pleadings need not be verified or accompanied by an affidavit. The signature of an attorney shall constitute a certificate by the attorney that the attorney has read the pleading or other paper, that to the best of the attorney's knowledge, information, and belief, there is good ground to support it, and it's not interposed for delay. So that rule indicates right there that a sworn motion, a sworn affidavit, or sworn testimony would be needed. The fact that it was signed by an attorney, according to this rule, is enough to verify it. So it does not need to be accompanied by any affidavit. Another one of the issues was that the problem with the trial court wasn't so much that it was that CEDAR Mountain Estate and DAL USA's motion for amended a motion for leave for an amended answer was filed at the 11th hour, but that really was the real problem the trial court had, not that it wasn't the problem. The trial judge did cite to Maui, M-A-W-I, indicating that the answer was insufficiently pled. However, they were not contradictory facts that were alleged, as Lone One argued and the trial judge believes. They were just additional new facts to supplement what was already pled previously. The appellee also points out the fact that Cedar Mountain Estates and DAL USA had indicated in their brief a long list of cases which were, I believe he said that they were extreme examples of when a motion for leave to amend whatever the pleading happened to be in those particular cases were filed, and also cited to Montero. They actually aren't extreme examples. I guess you could say that, being that there's no hard and fast rule that indicates when a motion for leave would be untimely or late within the case, it wouldn't be an extreme example in the sense that this particular case, it's even been less time. This was filed 1 business day prior to the motion for summary judgment. Rather, in those cases, it was the day of a jury trial, but before the jury trial was sworn. There was also one where it was heard the day of a non-jury trial, but filed a couple of weeks beforehand. So we have even less than what those cases have. In those cases, the DCAs the appellate courts had indicated that it was reversible error and abuse of discretion by the trial judge.
No affidavits have been filed, contesting summary judgment. Shouldn't trial judges be given some leeway in the ability to run a docket? I mean, here, you're set for a summary judgment hearing. No affidavits in opposition to summary judgment are ever filed. So everyone's coming into court on an uncontested summary judgment, and then one day before that, you all file a motion for leave to amend.
Actually, I believe that at the motion for summary judgment, since I was not there, but it's my understanding that there actually were no witnesses presented by Lone One when they filed that motion for summary judgment at that hearing. And I want to say, and I may be wrong, but I want to say it was telephonically as well. I believe Mr. Gordon, who was the trial attorney, was present in the court, but I want to say that Lone One was actually on the phone, I think.
What difference would that make?
Well, because there would be no witnesses for Lone One to be presenting, even if they had presented evidence.
When were the rules of civil procedure amended to allow you to present witnesses at a summary judgment hearing?
Well, and that's true, because Lone One could have just presented affidavits.
Right. The rules require you to present affidavits sufficient at 48 hours. I can't remember what it says now, but it's in advance of the hearing, correct? If they're going to be considered.
Right. Now, why didn't Cedar Mountain Estates and DAL USA present any evidence? And the reason why is because
You are out of time? Okay. Thank you very much. Thank you, counsel.
Thank you, Your Honor.